Welcome back, everybody, to the Law of Trusts. We are continuing talking about the constitution of a trust in this video, looking at the concept of perfecting the transfer of title. Now, there are a number of different rules, both in law and equity, that relate to this method of perfecting the transfer of a title. So there are a number of methods, like I said. We'll talk about two of those in this video, and then we'll talk about the every effort rule, which is another element in the next lesson as well. So, where the transfer of title is not completed to the adequate standard for the constitution of a trust, i.e. we have imperfect transfer or an imperfect gift, if you will, there are principles in equity which may be able to perfect the transfer of title for the purposes of this constitution. The first of this is known as fortuitous vesting, as cited in a number of textbooks that we have on this issue. This principle tells us that where there has been a promise to transfer property, but this has not been achieved, if the property is vested in another capacity in the hands of the person to whom the transfer would be received, then it has been held that the perfecting of transfer may be able to take place. Now, if you don't understand this, that's fine, that's perfectly reasonable, because it is not easy to explain just in terms of its general format. In fact, the best way of talking about it is to actually look at some case law on the matter. The rule as established in the principle of Strong and Bird tells us that fundamentally, if there is an imperfect transfer, if there isn't actually the perfected transfer to constitute the constitution of a trust, then this can be perfected when the receiver of the property is appointed as the executor of the will of the donor, and when the donor has the intention to gift that property at which that point they had died. So if they had intended to gift the property to this person, and this person then becomes the receiver of the property as the executor of the will, then it is seen to be the case that even if transfer had not been perfected before their death, on their death it had become perfected. So the case of Strong and Bird from 1874 illustrates this point. In this case, there was the borrowing of over £1,000 on the part of B from his stepmother. This, of course, is a significant amount of money, especially in 1874, but also particularly in today's standards as well. His stepmother had been a tenant in his house. As such, therefore, in order to pay off the debt, it was agreed that there would be a reduction in rent rent on the property, for around £100 every quarter, and this reduction will go towards the discharge of the debt. There was an insistence of payment of the full amount of debt under her death, when B was appointed the sole executor of her will. And so we have here an imperfect transfer, an imperfect trust, an imperfect constitution, and so the title needed to be transferred in order to perfect that, in order to perfect the trust, the gift, should I say? To perfect the trust. I'm just saying words. Okay, it was held, given these facts and these circumstances, by the Court of Appeal, that the imperfect transfer had indeed been perfected on account of two things. One, there was an intention to give that money in the first place, and two, there had been a legal transfer of some of the money, and then therefore the full transaction was perfected. This was the case despite the fact that the release of the debt would not have been recognized in law. So even though legally it was not a perfected transfer, the rule of fortuitous vesting in equity gave this position to essentially allow for the perfecting of title. Another way this could take place is through the principle of donatio mortis causa. What this principle tells us, and it refers to, is situations where the gift is made in contemplation of death. Okay, that's what donatio mortis causa refers to, donating, and then mortis refers to death. Normally, under the conditions of the 1837 Wills Act, when a will is created, it must be done in writing, signed by the testator, and the will must be witnessed by two people. Obviously, signed by the settlor, given the fact that they're a testator after death. So that's the ordinary prescription for how a will is created. It must also be the case that the two people who are witnessing the creation of the will cannot be beneficiaries of the will, as you can probably imagine. They have to be two third parties that are not involved in the situation at all. So this is the ordinary principle for how a will can be created. But what the principle of donatio mortis causa tells us is that it refers to requirements where this can be superseded by a deathbed bequest. So fundamentally, the three main requirements to satisfy this principle that essentially supersedes the view of the 1837 Wills Act is that you can, if you make a deathbed bequest, actually have this be part of a will and actually be a fully constituted transfer of, and therefore a constitution of a trust under these conditions. These conditions have been cited in the case of Cain and Moon from 1896. The bequest has to be made in contemplation of death. There is a requirement that the death be a conditional element of the bequest, and there is some actual or constructive delivery of the property. So, for example, if you go and see a loved one on their deathbed, they haven't made a will or whatever, or even they have a will but has different terms to what to what we're about to witness happens. They're on their deathbed, okay, and they say in contemplation of death, and that what they are going to do is give you their jewelry. Maybe they take off their jewelry and actually give you that property, and they say, "This is yours when I die." Okay, this would represent, even though it's not in the will and it is not actually a creation of a will, because this must be done in writing, signed by a testator and witnessed by two people. This deathbed bequest would, in all circumstances, actually constitute the trust on the basis of the principle of donatio mortis causa.